It's officially 10 o'clock. Welcome to an oral argument session before the 5th DCA. I'm Judge Edwards. We also have Judge Lambert and Judge Boatwright on the panel. We have one case this morning, and it's May 2025. The case is 24-1024, Michael Kirby versus Stephanie Kirby. Each side will have 20 minutes for the appellant. Typically, we reserve 5 minutes for rebuttal. If you'd like anything other than that, let me know. There is a clock in one of the little panes here on the Zoom. Green means you still have all of your time. Yellow means you're into your rebuttal, and red means it's time to stop. Mr. Wolfman, if I see you're kind of going on and not looking at that, I may try to remind you if I can slip a word in edgewise, but it's your time and you can use it however you please. So
please, thank you for that, Your Honor.
You betcha. With that, we'll proceed. Mr. Wolfman, whenever you're ready.
Thank you, Your Honor. A very brief question for the court. I want to make sure that I'm not violating any of the rules of the appellate procedure. My client is sitting here off camera. Is that acceptable, or should he leave the room and go to another room and view this in camera?
That's fine that he's there as long as he doesn't interfere with anything, and his phone is turned on silent, so that's fine. Go ahead.
Perfect. I wanted to make sure. Thank you, Your Honor.
We should restart. We should restart the clock back to 20.
Yeah, hang on 1 second. We'll have our. There we go.
Thank you. I appreciate that.
Now we'll start. Go ahead.
Perfect. I believe that all three of the judges in this panel have had more than enough time to review my briefs. My briefs have been, in my opinion, done to my satisfaction, that they have presented my case as best that I can. Oral argument is really to make sure that I answer any questions of the panel that they may have, rather than reiterate what happens to be in those briefs. I can quickly go over the generalized issues before the court, and then the court can ask me any questions that it has, because I know that you're prepared and ready to ask me any questions that you're not comfortable with, and I'd rather spend my time answering those questions and reiterating things that you're well settled. Basically, there's an underlying issue that surrounds the entire case, which is an unreasonable delay. In this particular case, we have a 22-month delay from the court's mandate on the first appeal in this particular case.
Why is that significant? I mean, it's one thing if it was the trial judge who heard the evidence and then 22 months later enters a judgment and there's a concern that she or he may not have recalled what was testified to. But this is a different judge who apparently has read the whole transcript and all the evidence and issued her a ruling that you have now appealed. So if you want us to reverse on this first issue, I'm just not getting a real good picture as to what we would do, saying, okay, we reverse because you took too long, so we send it back, it goes to that judge, and then she writes the same opinion and issues it a week later. What's the difference?
Well, in this particular case, we want a new trial if it were sent back. In the original remand, it was not retried. All the judge had to do was review the evidence in the record, review the judge's rulings, review the judge's finding of fact, and make a quick ruling in this particular case.
Did the issue come up about whether or not you could retry on remand? I thought both parties agreed not to retry the case on remand.
Our understanding of the reading of the mandate itself was it was not to be retried. That it was simply, and one of the problems that I think that we have that is the genesis of this whole issue is that the original appellate court who had the first case made the assumption, and rightfully so, that they were sending this back to the same judge. Unfortunately, our judge retired and refused to accept the case, and we were, for lack of a better descriptive word, stuck with a brand new judge. And I feel for that judge because she was really put behind the 8 ball and was put in a very difficult situation. But that doesn't excuse 22 months, Judge. And the cases that I cite in my briefs state several things that are very concerning about the delay. One is that there could have been substantial change of circumstances during this particular point in time, which there was. And in the record, my client halfway through this proceeding lost his job, had to file a supplemental petition for modification, And we still didn't even have a final judgment yet. That was 12 months into the remand. 12 months into the remand, the appellate or the lower court judge then sets a case management conference and says, I need help with this case. That's suspect alone. She ordered in that case management conference that both parties, for both the husband, former husband and former wife, provide her with three things. One was a memorandum of law that she wanted cases that she needed to look at. This is a year after the mandate. Number two, she wanted us to provide her with a proposed final judgment or a proposed order on remand or whatever it is that we thought that the court should execute in order to accommodate the mandate. And then number three, she asked for what issues should I, what parts of the transcript should I look at? And when I responded to that, Your Honor, and I hold this very dear to my heart in this particular case because it's terribly important. I explained to the judge on the first page of this, and this is in the record starting on R8609 through 8723. I specifically told the judge all the evidence needed to make this determination is received by this court at the trial, and the lower court judge has already made all of the necessary finding of fact. None of the finding of fact was appealed in the first appeal. It's all res judicata. I go on to say that the amended final judgment of dissolution of marriage should be reviewed by the court. I indicated with the above being said, there is no need for the lower court to review any of the transcripts. She did not need to review any of the transcript because, quite frankly, if she disagreed with the lower court judge, Judge Roberts, the original, she would be ruling against him, and that was not her mandate. Her mandate was not to retry this issue. It was to accept the judge's finding of facts.
Where do you read that? It says to reconsider the alimony award based upon the party's monthly net income and other factors under 61082. So it seems like that's exactly what she did. I mean, we didn't affirm anything. The prior panel reversed and remanded everything, took no positions on a number of your issues that you raised. I guess I'm a little, seemed like the trial judge did a diligent job as to what she was supposed to do with the task that she was given. I mean, and to say, and you seem to be criticizing that she asked for a proposed, where do you think I should look at? Please prepare a proposed final judgment. Please give me a memorandum of law. That sounds to me a good course for a judge who's taking on this task to ask just to help get her up to speed. I guess I'm missing why you have such emotive angst about that.
Well, one, it took her a year to come to that conclusion. Number two, I respectfully
let me ask that. Let's assume that that's not going to bother us, the year or whatever delay is. I mean, so you're now 7 minutes into your discussion. So if you want to proceed how you want to proceed, but let's assume that's at least not going to bother me. I mean, it should have been done faster, but it's not. It's a different scenario to me. So, but you make your argument as you choose.
Well, even if the court isn't bothered by the delay,
I don't think it's reversible error. I think it should have been done faster, but I don't think it's the end all be all that you seem to view it as.
Well, I view it in light of all of the other case law, both by the 5th District Court of Appeals and many other districts.
I'm aware of the case law. Counsel.
Okay, no problem. Now, going on in relation to the unreasonable delay, it also precludes my client from any relief as it relates to substantial change of circumstances. My client had a substantial change of circumstance a year into this, had to file a supplemental petition for modification. And mind you, we don't have a final judgment yet.
So what's he modifying?
That's my point. So what ends up happening, Judge?
What is the point by you? He moved to modify something that doesn't exist because because our panel reversed and remanded.
Correct. And let me get back to that very quickly. I respectfully disagree as to what was presented in the mandate. The mandate does not, and I've read many cases, and you guys have done this obviously more than I could ever read the cases. Every time the appellate court sends something back for a remand for a new trial, they specifically say, we remand for a new trial. We remand to take new evidence in order to make rulings consistent with this. The appellate court didn't do that. It simply sent back. And if you read the appellate mandate, it specifically says, hey, the only thing that we have here is $13,000 in net income. You must have used gross income. You can't use gross income. So I'm sending it back to you to tell us what net income you're using for alimony purposes. That's it. Not to retry this, not to do any of that, but to look at your finding of fact, determine what the net income is. And right now we only have 13 grand. And with 13 grand, you can't pay everything that you ordered. So you also have, and if you notice on the mandate, the appellate court was very astute in telling the lower court judge, and any factors under 61.082, and then revisit the alimony award, because right now we can't see that the husband can afford to pay that alimony award.
Well,
Now-
the opinion says if we rely on the former husband's monthly net income that the trial court used for the child support purposes, then the alimony is too high. But I mean, there's the if, it's the qualifier. So we
That's
weren't
correct.
saying that we weren't, but it doesn't, I don't read the opinion written by whoever, Wallace, that, you know, that is sacrosanct, that number. If we rely on it, then yeah, 13 minus, 13 net, 8,000 for 13 net with plus the child support is probably too high. So the trial, but why is the trial judge stuck with what the judge ruled the first time when it seems like there's evidence that suggests it's clearly erroneous?
Two
Right?
reasons. One, it was not remanded for a new trial.
Okay, go ahead.
Okay. Now, in that regard, the judge was then, and when you say it's not sacrosanct, I believe it is, unless
Okay,
the
I disagree with you. Go ahead.
Okay, unless, of course, the judge takes it upon herself under 61.082 to find additional income, which was not done. Now, going to your point, assuming that you disagree with everything that's been said with regard to the unreasonable day and everything like that, the judge still came up with my client's average income by using an historical average, which the state of Florida does not allow.
Well, let me ask that. Let me ask this. All right, I guess there's a lack of words you're saying in the opinion that if we sent it back for a new trial or whatever, and
Just on the net income, Your Honor, I want to make sure that that's very clear.
I
for
disagree
everything.
with that. But in any event, if they sent it, if Judge Roberts had never ruled, and this was simply a fresh thing coming to us in 2020. How is the opinion erroneous based upon the evidence presented at the trial? How is it reversible error? Isn't this completely within the judge's discretion to basically disregard the evidence that your client suggested was his net income and to come up with the net income calculations as she did? I mean, I get what you're saying is that the Judge Roberts already ruled, so this judge overstepped her boundary here. But if she was simply doing this anew, how would this be a reversible error in this opinion?
In my opinion, it would be because she used a historical average, which is frowned upon in the state of Florida, unless it's the only way that you can do it. The case law, as I read it, specifically state that you do not use a historical average, especially if you can determine through the evidence.
Did she actually use a historical average, or did she say his income was 100,000, then she looked at a $400,000 draw? I think she looked at another $100,000 draw, and then she said that's consistent with a historical average. But she looked to be calculating his income and then saying that was consistent, not that it was a historical average.
I disagree. I apologize. I didn't mean to speak over you, Judge, but I disagree because, in fact, what she said was she was rationalizing her $600,000 a year by saying, hey, look, he even made this in 2019. And he didn't make that in 2019 because the average that she used was 5 years before, and the $100,000 and the $400,000 draw were already accounted for in those previous years when she divided them by 5 to get $600,000. 600,000. So she created a fictitious $600,000 in 2019 by saying, oh, this is when he received those payments. He earned them and paid taxes on them in 17 and 18. And those numbers, when you look at the final judgment, the amended final judgment and the supplemental final judgment, when you look at all of the numbers that she used to add up and divide by 5, the 5 years that we're talking about here, then she's counted it twice, because his actual income for purposes of paying alimony at that time wasn't what she says it was.
What did the
That's
first
not
trial
his-
court, what did the first trial court say his amount was for alimony?
For
What
the
did-
ability to pay,
No, what did the first trial court come up with as his gross income for alimony?
that judge came up with, I believe it was roughly the same thing. It was something like $30,000 net per month, something to that effect. And the first appeal,
So I took your argument that you're saying we're stuck with the $13,000 figure for child support. We're stuck with that figure, but now you're saying we can look at a different figure of net income for alimony?
only if under Chapter 61082, there's additional sources of income that can be used. Because I believe that what happened in this particular case was the judge made a proper finding of my client's income at the date of the trial, which was $13,000. That's his base income. Where Judge Roberts erred is he didn't treat any additional income that he was bringing in to that $13,000 properly under Chapter 61082. And that's why the appellate mandate said, we're sending it back. You're basically stuck with 13 grand or any other factors under 082, which this new judge did not make any finding of fact under 61.082 as to any additional income.
Well, when I was looking in the record, the reason I asked you, I think it's on 7627. I see the number that he gets for child support, which he says child support only. And then when he discusses alimony, I'm reading it here, he says in 2015, his gross income was 659. Then in 16, I think he says 675. And then in 17, he says 850. So he appears to be looking at two different numbers, one for child support and one in alimony. Would you agree with that?
Yes, I would agree with that. And he did
Well,
not,
isn't it kind
one
of
of the reasons it got overturned was he did not properly use the additional income. The only time that you could ever have different net income for child support and alimony purposes is if you, under Chapter 61082, have additional sources of income for the ability to pay alimony. That's the only way that you can do that. And neither Judge Roberts nor Judge Spiker did that in any way, shape, or form. She retried the entire issue of income and used a historical average, which is frowned upon by the 5th District Court of Appeals. In some of your own cases cited by this 5th, you do not use an average.
Counsel, you have a little bit over 3 minutes left for your rebuttal. So again,
I understand, Your Honor.
Your
Did
time
any of the
is
judges have any other questions with regard to our appellate brief that I can answer for them before I reserve the remainder of my time for rebuttal?
I'm good for now.
As far as I know, we're still.
All right.
I reserve my 3 minutes then, Your Honor.
Okay. Ms. Harris.
Good morning. I think I'd like to start just briefly looking at the delay issue. First, I would suggest to you that the purported 22 months is not in fact what we have. I'm sitting here drawing a complete blank on the case name, but there's a case that reviews when the delay or the trigger point comes. And what we have here, and when I say trigger point, when the consideration, in a sense, when the case is ripe or ready for the court to review. And here we have many months of case management conference, transcripts being requested. This case was not fully ready for Judge Spiker to issue a ruling until June 7th. So While I have argued that the delay cases do not apply here because we're talking about a remand as opposed to a trial, I do want to point out that I believe that the alleged 22 months is actually not the case, that we're looking at maybe 8 months. And so with that said, I want to talk about two cases that talk about delay. They're Walker v. Walker and Adele versus Walker. They're two cases out of this court. I know you're familiar with them. In the first Walker, and if you recall, they are two instances of delay involving the same divorce, the same parties. So in the first instance, it was over 9 months, and the court said, well, it's clear that the judge is confused. He's forgotten something. There's contradictory, confusing provisions that make it evident that the court has forgotten something. And why that's important is the very reason the court wants prompt rulings is there's the assurance that the court's remembered the evidence, is recalling the evidence properly, is understanding the dynamics or recalling the dynamics of the trial. That's really the crux of why we want prompt rulings, is this assurance that the court has remembered. So now Walker gets remanded back, and now there's another substantial delay. My recollection, I handled that case. My recollection is that it's 18 months past, but be that as it may, ultimately what happened there is very much like what happened here. The final judgment says, I reviewed my copious notes. I read the entire transcript. I looked at all the evidence. I looked at the exhibits. My notes even had credibility notes on them. And the court said, well, there's nothing in this final judgment that suggests that a delay somehow affected the court's ability to recall. So even if this court were to agree or disagree with me that the distinction or the inapplicability of those cases comes on the remand, even if the court were to say, Mrs. Harris, I don't agree with you. I think it applies in this circumstance. We can't reach that point here because there's nothing to suggest that the court somehow didn't remember something, somehow didn't recall the evidence, because she's very clear that she did a laborious, meticulous review of this case. And this court knows how extensive that record is. It's substantial. I think presently before this court, it exceeds 8,000 pages, and that's what she reviewed. So I believe that there is a distinction between a remand and issuance of a final judgment after there's been a close of the evidence. I believe that that is significant here and puts this totally outside of the context of those cases. Now, with respect to this concern that there had been substantial change in circumstances while the case was pending, if I recall correctly, I think it's in the Stanfield case that's cited in the briefs. In that case, there was a motion to reopen the evidence. We don't have that here. We don't have any of that happening here. And my research did not reveal or uncover some preclusion from that having happened on remand. So I believe that also defeats or diffuses any substantial change in circumstance concerns that may have been presented either via the Stanfield case or the delay that may have occurred here. Now, I think it's important, two other points I want to make here. The former husband is using the word retry, that the judge retried this case. The judge didn't retry this case. I think it's important to remember that in the first appeal of this case, I handled that case as well. And Mr. Kirby at that time asked this court for a new trial. And it's apparent that that's not what this court did in Kirby 1. They denied his position that this warranted a new trial. And here we are again before this court again requesting another new trial. That is the distinction should be drawn, because they're requesting a new trial yet saying the judge retried this. What the judge did is exactly what this court directed it to do. You can't reconsider alimony. You can't consider the factors in 6108 without reading the transcript, without looking at the evidence. You can't comply with this court's mandate, which there was a little bit of talk about the directions of the mandate. Mandates as this court is very well aware, there are specific and there are general mandates. What we have here, I would almost propose, is somewhat of a hybrid of the two. We have the court directing that there be a reconsideration of equitable distribution, the attorney's fees, as well as a determination of the net income and the corresponding need and ability to pay. Now, in that directions, this court could have, at the time of Kirby 1, said the finding is $13,000. This court did not do that. And I believe, Judge Lambert, you've already highlighted what I believe is the critical word in this opinion, and it's the word if. Moreover, if. It's clear that this court did not take that as the net income finding. This court certainly had the ability to have said, trial judge used $13,000 as the net income and recalculate this. As a matter of fact, that paragraph beginning with moreover, if, could have been the central holding of the court. Had that been what the court was doing in this case. That paragraph is a secondary reason for reversal. The primary reason was, in fact, that gross income was used. And I think that it's imperative for the analysis or the direction that was provided to the trial court that we look at the actual holding of the court, which is gross income was used. And if you rely on that, then there would be a reversal, but it is not clear, or it is clear rather, that the court did not use the $13,000. This court did not. Finally, there's talk about the average income. The case law on average income or using historical, and it talks about when there's uncontroverted evidence that there's been a reduction in evidence. And both before Judge Spiker, and even when you look at the what happened in Kirby 1 in this case, there's argument made by Mr. Kirby that there's contradictory evidence regarding his income. So we've had a situation where he's argued that his income was $13,000, his net income, in light of substantial evidence to the contrary. And when you have that, the court is able to say, a trial court is able to say, I don't accept this and I accept the other. And that's, I believe, what happened. Truthfully, I think it happened with Judge Roberts' ruling, that he did not accept that there was a reduction in earnings. And so I think the use, and I think Judge Spiker did that as well here. There's certainly a basis to determine that there is contradictory or conflicting evidence regarding the evidence of his income, and certainly it is within the duties of the trial court to make that decision. I don't have anything else. Should the court have any questions for me, perhaps I'll just say very quickly in passing, with respect to any argument that arrearages were made, and that was outside of the mandate, I would suggest to the court that arrearages, in fact, were not made. There is no order as to arrearages. There is neither a stay in Kirby 1 nor a stay in this case. And so the court simply says, this is what would be owed. You get a credit for anything you've paid. So I would argue that, in fact, any suggestion that there was arrearages order is not the case, given the language of the final judgment. That's all I would have, unless you have a question for me.
Unless my colleagues have any questions, which they don't seem to, we're back to you, Mr. Wolfman. Thank you.
Thank you. Starting the last first, there was most certainly an order for arrearages. They were ordered to be paid in a lump sum within 30 and 90 days, all without a substantial finding of fact or a significant finding or any finding of fact as to the ability to pay those lump sum amounts and from what source. So I think my brief is very clear on that. opposing counsel argues that the case law with regard to the delay is primarily just to make sure that there's no conflicting evidence or to make sure that the judge knew what he or she was talking about, remembered the evidence and all that. That's not at all true. The case law is very clear, and it says
Let me
that
ask counsel,
you-
let me step back to about the arrearages. There doesn't need to be a determination of the ability to pay or sort or whatever. I mean, if you have a contempt proceeding, then there's an issue, but I mean, the arrearages is a mathematical computation, isn't it? So either they are or they aren't. If they don't pay it, then there's another step. And if your client,
well, if
has
you're
no
ordered
ability
to
to
pay
pay.
it, if you're ordered to pay it within a certain time in a lump sum, it most certainly is.
well,
It's
no,
no,
if,
it's
if,
no
if,
different.
if he was hit by a car and he was in a coma 10 days after that, and he had no more ability to do anything, and I'm certainly not wishing ill health on him, then that
Sure.
would be a fact that you'd say, well, yeah, I was ordered to pay, but I can't because I am no longer able to work. And judge, you can't hold me in contempt.
Well, no question, but this isn't a question of contempt. This is a question of whether a judge can order a lump sum amount at a particular time from no source or ability to pay. The cases are very clear, Judge, that you must have, before you can order $100,000 due within 30 days, you have to have a finding of fact of ability to pay and from what source that income, that payment is supposed to come from. The cases are dead on clear. I don't know how I could explain that any clearer, but going back to the issue of confusion and conflicting results as it relates to the delay, I go to great lengths to show this court exactly all the things that were caused by this delay in the poor nature of the supplemental final judgment. The supplemental final judgment on numerous occasions went far beyond the mandate with regard to child support and other issues. The supplemental final judgment is confusing as to its content. It doesn't say when alimony is supposed to start. It has lump sum arrearages, and it doesn't say what those arrearages specifically are for. And it has 2 paragraphs that talk about arrearages, but you can't tell whether or not one arrearage is included in the other. It orders $150,000 in arrearages for equitable distribution and attorney's fees, but it doesn't say how much of the is for attorney's fees, how much is for equitable distribution. So the cases were very clear that it goes on and on about if the final judgment is confusing and conflicting upon its terms, then that is the criteria that you use in order to determine whether or not the significant delay was prejudicial to either party. And in this particular case, I believe it's replete with problems.
Counsel,
And-
we've reached the end of the time.
Yes, sir.
Unless my colleagues have further questions, we will be in recess. Thank you both.
Thank you.